Hey guys, I'm Caleb Giddings here for GAT Daily, and boy do we have an interesting news story for you. After long last, the Supreme Court has once again taken up a gun rights case. That's right, it's taken the New York Rifle and Pistol Association versus Corlett. Now, if you'd like to read more about this case, our editor has already posted on the GAT Daily website about it. So just head to gatdaily.com if you would like to read this with words. However, if you're the sort of person who likes to have another person talk to you and explain these things with their words, stick around for the rest of this video. So there's a lot going on here with this case. There's a lot going on with why the Supreme Court hasn't taken gun rights cases for a while, and there are a lot of tremendous ramifications for gun rights with the Corlett case. So let's go through this piece by piece, shall we? First, we're going to start with why perhaps the Supreme Court hasn't taken any gun cases for a while. If you remember, if you're a gun rights enthusiast, a gun rights activist of a certain age, you remember the world before Heller, the world before DC versus Heller. Heller was the first major landmark Supreme Court case to put in plain English what we always knew about the Second Amendment, was that it conferred an individual right to own a gun. That's it. Supreme Court ruled, okay, you have an individual right to own a gun. Awesome. At the time, that was sort of limited in scope. And then along came the McDonald case. The McDonald case said that the Second Amendment is just like all the other amendments, and it is incorporated, meaning that it applies equally across the board to the states and not just to the federal government. So after Heller and McDonald basically established what we already knew, that you had an individual right to own a gun, we've kind of had a pause on Second Amendment decisions for a while. Now, there's a number of theories about this, the most prevalent of which is that the four, at the time, pro-gun justices didn't want to take a case that might be swung against gun rights. And that's because the Chief Justice is very much a moderate. He's not a staunch rah-rah Second Amendment guy. He's kind of a moderate dude. And there's nothing wrong with being a moderate dude. I disagree with some of his opinions and I disagree with some of his rulings, but that's just what it was. Now, with the appointment of Justice Barrett, it seems like we've got, at the very least, a guaranteed 5-4, possibly a 6-3 majority on the court. But, you know, I fully trust that all of these justices will decide a case based on its merits and not on some sort of political persuasion, as we have seen already with these conservative appointees. However, I kind of have a good feeling about this. So now that we have a theoretical conservative majority on the court, it is safer for the court to look at this gun rights case. And why this case is so important is because this is do you have a right to carry a gun outside of your home case? And this is an especially important issue right now because the Ninth Circuit recently ruled that essentially there is no right to carry a gun outside of your home. And I believe, I'm going to get this one wrong, there's another circuit that ruled that there is a right to carry a gun outside your home. So we have what's called a circuit court split. And a circuit court split happens when one court says one thing and one court says another thing, and they don't agree on the thing. And one of the important roles of the Supreme Court is to resolve these circuit court splits and say, nope, these guys got it right, these guys got it wrong. This is what the law means, guys. So that's a big part of why this case is important, is because if the Supreme Court rules in the favor of the New York Rifle and Pistol Association, it means that essentially there is a right to carry a gun outside of your home. So let's get into the details of this case, all right? So these two men, who are also backed by the two plaintiffs, challenged the state law. I'm just going to read you what Keith wrote because it's easier that way. The law at issue in the case, NYRPA versus Corlett, is similar to gun control measures in other states. To receive an unrestricted license to carry a concealed firearm outside the home, a person must show proper cause. That's in New York, meaning a special need for self-protection. Two men challenged the law after New York rejected their concealed carry applications, and they are backed up by these gun rights advocacy groups. The Second Court upheld the law, prompting the challengers to appeal it to the Supreme Court. The heart of the law is New York's may issue carry permit, in that they may deny you a carry permit if you can't demonstrate sufficient cause to carry a weapon. There are very few may issue states left in the country. So what the plaintiffs are saying is that their application was unfairly denied, and they are essentially suing the state of New York to go from a may issue state to a shall issue state. If the court rules that New York's law is unnecessarily strict, then we could end up with a shall issue state in New York, which would be a wild world that I can't even possibly imagine right now. But there are a whole bunch of things that could happen as a result of this case. So, assuming for the moment, and this is a big assumption because Supreme Court justices are tricky creatures. In my lifetime, I've seen justices rule in ways I never would have thought they would have ruled. So you cannot assume that we will get a pro-gun ruling out of this case. You absolutely cannot do that. Can't assume anything with the Supreme Court. It's a wild house in there. But let's talk about this. So the facts are the two guys sued the state of New York saying that their permit applications were denied unfairly. The state says, no, the applications were denied fairly, and there's no constitutional right, essentially, to carry a gun outside of your house. A whole bunch of pro-gun groups have jumped into this thing. You've got Firearms Policy Coalition, National Rifle Association. Like, there's a lot of pro-gun advocacy and cheddar going at this case, which is a good thing. Now, here's what we could get. Here's a couple of scenarios. The justices could very narrowly, assuming they rule in what we will call a generally pro-gun ruling, they could rule very narrowly that New York's specific law and the way it's implemented is, in fact, unconstitutional. And that would essentially only affect New York State, and it wouldn't create a broad precedent establishing that the whole country should be shall issue, essentially. And that's, in my opinion, that's the most likely scenario, is a narrow ruling from the court that says the way New York's licensing scheme is set up is unconstitutional and it unfairly denies people the right to bear arms. In that ruling, there could be some language that there is a right to bear arms outside the home. There might not be. It's tricky. That's why I think that one's the most likely, mostly because I'm a pessimist and I don't think that we're going to get like a sweeping victory here. Now, the best case scenario, the thing that would have me tap dancing through the streets and taking a day off from work to celebrate this great pro-gun victory, which I don't think is going to happen, but could be that the ruling is such that it says that New York's may issue licensing scheme is unconstitutional because a reading of the Second Amendment clearly states that there is a right to bear arms outside of the home. And a ruling like that would essentially make any sort of may issue permit scheme unconstitutional, just on its face. So there's only a few states left that still have may issue permits: New York, Massachusetts, Hawaii. I think there's probably a couple more that I can't remember, and they're probably all up in the Northeast anyway. So, but that would then firmly establish that those permit systems, California, duh, how could I forget California? But anyway, a ruling like that would strike down all of these may issue permit systems, and it would essentially create a national standard for shall issue permits, which is what it should be anyways, regardless of how you feel about carry permits. You may be like, any permit is one of those any permit is unconstitutional guys, and while I agree with that in an academic sense, baby steps, homie. Baby steps. We won Heller and McDonald, and look at all the constitutional carry states that we have now. Give it time. You win, you get New York to go to shall issue, you get California to go to shall issue, and then you can worry about getting them to constitutional carry and all of that. But that's the future. Our best case scenario is a broad ruling that not only strikes down New York State's terrible permit issuing system, but also strikes down the concept of may issue permit systems as unconstitutional. But the good news is that SCOTUS took this case to begin with, and with the kind of bam, bam that we've been getting on the gun rights front lately, kind of getting hammered by some of these, some of the things from the new administration, I am going to say that I am cautiously optimistic about the justices in this case. Very cautious, very cautiously optimistic. But SCOTUS has taken a case. It's a very important case, and if we win, change everything, man. May issue going away. Oh, how great would that be? If you want more information on this, again, check out the website gatdaily.com. Keith has a great article about it. I think you'll enjoy it. I'm Caleb Giddings for Gat Daily. Thanks for watching.